On March 8th this year, celebrated as Women's Day world over, a Muslim couple in Kerala got remarried. Why is this headline material, you ask? Because the couple from Kasaragod was doing so to address the inequalities and gender bias inherent in property rights under the Muslim personal law. So why are inheritance rights under the Muslim personal law considered discriminatory towards women? Let me explain. Nearly 29 years after their marriage, lawyer and actor C Shukkur got remarried to his wife Sheena, a former pro-vice chancellor of Mahatma Gandhi University, on March 8th. The couple, who had gotten married under Islamic law back in 1994, this time chose to marry under the Special Marriage Act. Their decision was influenced by the fact that they have 3 daughters, and under the Muslim personal law, they would not be entitled to fully inherit their parents' wealth. So why is the Muslim personal law considered discriminatory towards women when it comes to property rights? How inheritance is distributed between men and women is different under the Muslim personal law. Take a look at some of these scenarios. 1. A son can fully inherit his parents' wealth, but on the other hand, the sole daughter can only take half the share. The remaining share is distributed to male relatives, like the father's brothers, for example. 2. If a couple has more than one daughter, like in the case of Shukkur and Sheena, who have 3 daughters, they would get 2/3 of the inheritance. Once again, male relatives would stand to legally inherit the remaining share because there is no male heir. What's more, the daughters who want to sell or pledge their inherited property will have to get the permission of their relatives to do so. 3. If there are sons and daughters, then under Muslim law, the daughter ceases to be a sharer, meaning they are no longer entitled to a share in the property. Instead, they become recognized as residuaries, meaning they get what's left over after the brothers have taken their share. In simpler terms, under Muslim law, each son gets double of what each daughter gets. 4. A wife gets 1/4 of the share if a couple doesn't have children, grandchildren, etc. But that share reduces to 1/8 if the couple does have lineal descendants. The husband, on the other hand, gets half the share if a couple doesn't have children, grandchildren, etc., but gets 1/4 otherwise. 5. A widowed woman will have no right over her husband's inherited property. For example, if a son dies, his wife and children will have no right over his father's property. Now, even if Shukkur did make a will in favor of his daughters, it wouldn't change their circumstances, because the Muslim personal law determines how the share of wealth or property is distributed among heirs. So, how does getting married under the Special Marriage Act help Shukkur's daughters? When a Muslim person gets married under the Special Marriage Act, they cease to be a Muslim for the purpose of inheritance. After their death, their properties do not devolve under the Muslim laws of inheritance, but instead are governed by the Indian Succession Act. This means that Shukkur's daughters will be able to fully inherit their father's property. Shukkur's move to get married under the Special Marriage Act has revived the debate on equality and gender bias under the Muslim personal law. In fact, a petition challenging these very provisions of inheritance under the Muslim personal law is pending before the Supreme Court. But his remarriage hasn't gone down well with some members of the Muslim community, including the Council for Fatwa and Research, which accused Shukkur of insulting religious rules and of destroying the morale of believers. But Shukkur had told my colleague Harita John earlier that his intention wasn't to challenge or disobey the rules under the personal laws, but to depend on the Constitution for equality. Those seeking reform of the Muslim personal law point out that even when the Hindu and Christian personal laws were reformed, there was strong opposition from within the respective communities. Remember the Mary Roy case? It was her long legal battle that ensured equal property rights for women from Kerala's Syrian Christian families. The educator and activist had gone to court in 1983 after she was denied equal rights over her father's property. She challenged the Travancore Succession Act, under which daughters from the Syrian Christian community had no right to inherit property. It was thanks to Mary Roy's fight that the Supreme Court delivered its landmark judgment in 1986, nullifying the Travancore Succession Act and ruling that the Indian Succession Act would apply to all Christians in the country. Similarly, in 2005, Parliament amended the Hindu Succession Act to give daughters an equal right in parental property. Since then, the Supreme Court has upheld the right of a daughter to be entitled to an equal share as a son to ancestral property. So while Shukkur's decision to remarry his wife under the Special Marriage Act has set a precedent in ensuring gender justice for Muslim daughters, whether his move will lead to wider reform remains to be seen. But before I go, a quick reminder that we've been bringing you Let Me Explain for over a year now. So if you value the journalism that we've been doing, do support us by becoming a member of the News Minute. Also subscribe to our YouTube channels. And as always, if you like this video, hit the like button and share this video with your friends.